Hello viewers, welcome to our program on immigration and you. And David, thank you very much for being on the program today also.
Thanks
My
so
law
much,
partner,
Michael.
David Nachman.
Happy
And
Father's Day, Michael.
Happy Father's Day. I was going to say that in Hindi, Urdu. This is the time कि आप अपने father को celebrate कीजिए June 20th को, birth Father's Day. You take your father out, treat him, and that's a nice thing. So many things since the birth, he has brought you up. He has done so many things for us. So let's not forget the father. The purpose of the Father's Day is people here in America are so busy, right? They forget even the family's birth dates and all that. It's different in our culture, though. Right. There's Father's Day. Every day is a Father's Day. Right. But anyway, you say what you need to say.
Right. Well, I also wanted to just let everyone remind everyone to say Happy Father's Day to your fathers. Give him a call.
Thank
many
him,
times.
Take him, treat him.
Yeah, we hear very, very distressing stories about people who are separated from their families. Pick up the telephone, use Skype, call your father, say hello, tell him how much you miss him, tell him how much you care.
Okay. Let's continue with some of the things we were talking last time on administrative processing. And the other issues related is that in the old times, I mean, this change has taken place now. Before this change took place, employer will file a petition, H-1B, for an employee, get through the lottery program, H-1 is granted, and H-1 is good for the location for which the LCA, labor certification attestation, is filed. Many of the employers, what they used to do, instead of in the petition they said work in New York, but they will send him in Los Angeles, San Francisco. But they say, it's okay, what's the difference? But that was a wrong thing to do, because the LCA, labor certification attestation, is based upon the prevailing wages in that particular area. So the government says, immigration says, rule says that if you're going to a place, St. Louis, for example, much less salary, that's what you said in the petition you're going to pay. No, you are sending to Los Angeles where the salary rate is completely different. So some people got in trouble. You can talk more about audits and trouble coming out of those things. But one good thing that they have done is they have clarified very clearly now that if you are shifting the employee from one location to another, just get a new LCA and file an amended petition. And that I think the difference between amended petition and regular petition, the fees are much lesser in the amended petition than going through all the fraud charges and everything else.
Well, the government, Michael, went a step further. It was actually a matter of Simeo Systems. And in the case that came out, it was one of these special decisions that the USCIS came out with. So it is considered binding. And essentially what they said, just to echo what you said, Michael, is that they're saying you must file a new LCA if you're changing the geographical location of the individual where it is beyond what's called, it goes beyond a geographical area that takes it out of an MSA, a mean statistical area. So if it's out of a metropolitan statistical area, then you have to file an amended labor condition application. And I think that the politics behind it's kind of interesting is that this is really additional scrutiny that's being brought upon the industry, the H-1B industry, the consulting firms that first it was AC-21. That really focused on this industry. There were requirements for H-1B dependency, where if there were H-1B dependent employers, they were required to do additional postings, to do additional attestations, and now we have this. Requirement where if you're transferring someone into an area where there's, again, a different metropolitan statistical area, and you have to amend the LCA, you need to amend the H-1B. And the question now becomes...
There are three reasons. I mean, even if technically, if somebody only does a LCA, does not file an amended petition, there may not be a bigger problem.
That's what they were doing.
Yeah, but they were doing that. But some problems comes out of like this. We go to American Consul for visa processing. He says, where are you working? He says, San Francisco. But your LCA says, petition says that it is for New York. So this is a violation. And then they keep on pending to 21G, the problems go on. Because how did LCA, he just gets it done and keeps in his file. Immigration doesn't know. USCIS doesn't know about that. So this way, if you file an amended petition, you have approval of the amended petition. Then you go to the American consul and he says, oh yeah, you took proper steps, and that problem is then much more or less resolved.
Right.
So instead of fighting and trying to convince the consul, I still did the LCA, just give him approval notice from USCIS. Amended.
Yeah. Well, I think that at least for us, what it has signaled is that there is much more planning required.
Right.
And what we do is we try as much as we possibly can to ascertain what the itinerary of the individual is going to be when they're taking up this H-1B position. And what we'll oftentimes do to be extra safe is that we'll designate more than one geographical location on the labor condition application. So for example, if the individual, let's say, is let's say they're out of a New Jersey IT company and they're working in Oregon, then of course we will designate both sites. We'll designate the Oregon site and we'll also designate the New Jersey site, with the expectation that once that position in Oregon is possibly eliminated, the individual will be brought back to New Jersey. They'll be working in the New Jersey site, and hopefully until such time that we can figure out what the next project's going to be, if we don't already know what it is. And then what we do is we amend the H-1B and send them out to the other site. Now, the other thing that you have to be mindful of is that there's also sort of an exception to the rule, or I guess you say we call it creative lawyering or wriggle room. And the wriggle room, if you will, is that there is something called short-term placement opportunities. So employers with H-1B employees are allowed to place employees for a period of between 30 to 60 days if it's a short-term placement. Or if it's referred to, there's also another term of the art that's referred to as peripatetic. So if it's a peripatetic position, that's also sort of subject to, is outside of this rule. But I think, again, what they're really trying to do is they're really trying to focus in on the individuals who are getting LCAs approved for wages which are very low wages, and then transferring individuals to, exactly. And it's the same, it's interesting, it's the same sort of thing, history repeats itself. I'm sure there's a Hindi saying for that, right? That history just keeps repeating itself. And what we see is if you look at what happened with the medical doctors, the HUD waiver program was online, and what they were doing is the insurance companies were getting doctors and they were taking them from lower income areas and transferring them to high income areas, and that whole program was taken offline. So it's kind of interesting to see that this is sort of what they're going for, because they can see that this is maybe an issue and they're trying to avoid the potential for this happening.
We do a lot of audits on the H-1 cases. No, the audits is not just a problem for employers. Well, it affects both the employer as well as the employee.
Exactly.
Right?
Right. And you have two different types of audits going on. You have site visits, correct, which are normal visits where individuals who have, or companies that have submitted H-1Bs, the USCIS is coming to see whether or not the individual is actually performing services in that place. Or you also have the U.S. Department of Labor that conducts a wage and hour audit, which has to do with whether or not the individual is being paid the federally mandated prevailing wage, which goes to that LCA filing that you make for the H-1B.
So if the employee says, right, not my fault, employer said 50,000 in the petition, but then he started giving 40, or he started putting me on the bench, I didn't want it, so it's not my fault. Will that fly?
Well, so you're saying that the individual is saying
it's affected, I'm saying, by these violations. It's not just the employer who is affected, and the audits and the fines and all that. Even the employees maintaining a status.
Right.
That becomes a problem.
Of course.
And that kind of client, that kind of person goes for visa processing before the American consul. Believe me, what's going to happen.
Right. It could come under 221G, and there could be questions
sitting
about
there forever.
Exactly.
So this is a good. This plan is a good thing. Be very careful. Do everything correctly. Follow the rules. Get a new LCA. Get the amended petition. Keep all the records. Benching is not allowed. Benching is not permitted. You are not supposed to reduce the wage. just because you don't have a client or customer and all that.
Exactly. Well, the rules are very discreet, and obviously we always recommend to our clients that they should follow the rules as much as they possibly can. And there are, of course, exceptions where individuals, hardships are thrust upon individuals by employers, and that's one of the reasons why the U visa, the Department of Labor has decided that what they're going to do is they're going to sign U visa certifications. So, it's something employers have to be really mindful of, is that, if an employer is not paying the wage or not treating an employee properly, then potentially the employee could get a U visa, not even worry about the H-1B, get a U visa, and then all of a sudden the house of cards comes down on the employer because the employer is not treating the employee properly.
Yeah. Okay, let's go back to one of the items on the last program. We talked about the detentions. This is a very good article I read on detention of the people who are apprehended. And they are saying there are about 442,000 cases pending before the immigration judges all over the country. Why the dockets are so backlogged also? Because the number of judges is much lesser than the number of the cases that are put in there. Maybe might have reduced a little bit now, but even now there's a lot of cases they can't handle. So what they do, they detain a lot of cases, they detain the person in the detention center, like a jail, you can say. How many of people are detained for small violations like that? Government spends thousands of dollars.
Exactly.
Not only that, what does it do? It gives a hardship to that person, a family also. The husband is in the jail, and the wife and children. They should really strictly, again, follow the priority guidelines. As number of less detentions they can do, they should do.
Right. I absolutely agree with you, Michael. And in fact, I had this discussion recently, believe it or not, with a member of my family. And one of the things that I was pointing out to them is that, detention is a huge business.
Yes.
It's really for these detention centers, they're getting huge
millions of dollars,
huge money for us as taxpayers that we're paying to have individuals in detention. I have plenty of stories where we have individuals who we've tried to get out of detention, and the government wouldn't let them out of detention because they held them there for several weeks, where the individual, all they wanted to do is take what's called voluntary departure, VD. And that's an argument that you can use if you want to leave with no prejudice to you. Yeah. What you do is you say, I want voluntary departure. And I said, how difficult can it be to get voluntary departure? The government held the person 2 weeks beyond my notifying the trial attorney that they wanted to take voluntary departure.
Because they make money.
Because, exactly.
The more they detain, more people their money.
It's a business.
That's useless. That's not really warranted at all.
It's very frustrating. But at the end of the day, it's a business. And that's...
so what is happening because of this? Some people that they have a hearing, and they put the date another 1 year down the road. People are getting hearings for maybe a year down or 2 years down now.
Exactly.
Because the judge's calendar is full for another 1 year or 2 years.
That's exactly right.
So that's really crazy.
Yeah.
Interesting question.
Please.
This is something I'm not talking about any TV program or anything. But there are some, I see on the TV all the time, and some people tell me also, some astrologers who say that, that they can do anything, basically court cases, immigration, everything, whatever you have in mind can be done within 1 week, guaranteed. How would that work? I mean, it's like a magic, How can that work?
In other words, that you're saying, how can they guarantee that the result is going
1 week are guaranteed, results are guaranteed, whether immigration court, whether divorce, whether there's immigration problem, whether there's any other thing,
I would say they're out of their minds.
Okay. Well, I'm glad you said it. You said it.
But here's the thing: is if anybody can give a guaranteed result like that, please let me know, because I'd be more than happy to send all my clients there. So.
Yeah, maybe we can invite one of those guys in our program. He can help us to understand how that works.
Probably not a bad idea. Yeah.
Okay, we have some time left. Very quick.
I think we're just about to the end, though. But yeah.
Okay, so any latest information you think we may be giving them next week? Well, one of the questions comes from the people where they have brothers, sisters waiting 12 years, 13 years, 14 years, and they say, how about investment, EB-5 program? We always say, put that on a side. This is last. Let's explore all other possibilities. But there
Exactly.
may be some cases where the people have all the money, they don't want to wait 10 years, that may be an option. But in the next program, we can give them a little bit of information on you do your own investment, or you have the regional centers for it.
Exactly, and I just want to let our viewers know that this weekend, this is a pre-taped show. This weekend, I'm actually at the AILA conference in Washington, D.C., where we're meeting with all the other immigration lawyers in the country who are active in AILA, as well as the governmental officials who deal specifically with the U.S. Department of Labor, the U.S. Department of Homeland Security, and all of the other administrative agencies. And we'll be bringing to you updated information on probably a regular basis after this show. So we just wanted to let everyone know that.
Okay, lot more good information to come in our next program. So if we are coming to the end of the program, we thank you very much for coming on the program.
Thanks so much,
Thank all of our viewers for being on the program. Please keep watching us every Saturday and Sunday at around 11:45 a.m. and we'll give you most recent and helpful and valuable information to you every week. Thank you and goodbye.